So this is the headline. It's a new dawn in child protection here, but let's try and understand why we are calling it so. Here's understanding how the Supreme Court effectively has not just changed the name of the crime, but also the game. Effectively, it will no longer be called child pornography. So the Supreme Court is very clear, do not call it child pornography. In fact, the Supreme Court wants it to be referred to as child sexual exploitative and abusive material, forming the acronym CSEAM. Child sexual exploitative and abusive material, CSEM. That's what the Supreme Court says. Now, what does this mean? The Supreme Court is very clear. Watching child pornography, or CSEM, is an offense from the Supreme Court. Very, very clear about it. Downloading child porn is an offense. Again, no two ways about it. Storing child porn is an offense as well, and even deleting it after you have downloaded it and viewed it is also very clearly an offense of the IT Act, offense of the POCSO Act, according to the Supreme Court here. Now, why is this important here? Let's put out some data here to understand India's rising threat when it comes to child pornography here. The number of cases that were registered in 2018 were 44. In just 4 years, it shot up to 738. That is a difference of a 1,600% increase, a whopping increase as well. Let's look at, in terms of arrests as well, there's a similar jump here. From 36 arrests in 2018, it has shot up to 372, which is again an increase of over 933%. There is a reason why it's a matter of concern for the Supreme Court here. Now let's look at CSEAM material on the internet, or for the sake of convenience, what we see as child pornography on the internet here. In 2021, the cases were 1,63,633 cases of inappropriate child content involved through pornography on the internet here. In the next year itself, it shot up to 2 lakh plus, which is an increase of 24.7%. But then look at the significant increase in the year later. In just 1 year, from 2022 to 2023, the figure shot up to almost more than double, 4,50,000 cases, up 120%. That is data coming in from the NHRC, National Human Rights Commission here. So you understand why the Supreme Court is so concerned. And which is why the Supreme Court wants us to be very clear about the fact that there are no gray areas when it comes to child pornography. It is essentially child exploitation and abuse. However, it's one thing to term it an offense, it's another thing to police it. Here are some of the challenges you'll face. One is lack of awareness here. We at Mirror Now are trying to make it a headline story, which is why we have covered it to so much of detail. But the fact still remains that this is not something you would see in a lot of newspapers and a lot of news channels today. So there would not be abuse as to what is correct and what is not correct, absolutely, when it comes to watching pornography. Then there is overburdened courts. It's a case, how many of these cases will actually reach the courts, and how many of these cases will be addressed in time? Then, of course, anyone who watches pornography knows that there are various methods in which you circumvent the law, which is always 2 steps beyond you. You can use VPN, you can use the dark web, you can use encrypted platforms. It's very difficult to trace someone who's actually consuming illicit material. And then, of course, there are jurisdictional challenges here. How do you police what, under whose jurisdiction it comes in? And the lack of agency coordination. To understand that this is still a topic which India is trying to understand the ramifications, how exactly we counter it. There's always a fear that we will be a step behind when it comes to the criminals and understanding it. But the first important step in this regard has been made by the Supreme Court in not just redefining what it means to be what it means to have child exploitation and abuse material on the internet, but also, importantly, also reversing and rejecting a Madras High Court order on the same, which is how this case came up. To understand it more, let me go across to my guests here. Khushbu Jain, noted advocate in the Supreme Court; Soumya Jogi, psychologist; N.S. Napinani, senior advocate; and Meenu Pada, lawyer and child rights activist. Thank you all for joining me today on this panel. Let me start, of course, with Khushbu Jain. Ma'am, for the benefit of our viewers, I've tried my best with my team to try and break it down for the importance of it. But if you could give it to us from a legal perspective, someone who understands the Supreme Court very well, why was today's judgment or today's verdict hailed as a landmark verdict in the Supreme Court, even though it even counters and rejects a previous High Court judgment? Khushbu Jain ji, that question was to you.
Addressed to me?
Yes.
See, if you look into the judgment is purely talking about giving importance that this is something which is an heinous crime. And despite laws being in place, the judgment which was passed by the Madras High Court appears to be very erroneous on the face of it that when you talk about pornographic content involving child, it is not restricted to something which is done, which is an aftermath that, some content which is there and which is put out. There has to be an element where an abuse is involved. When you're doing something, you're considering child as in property or as a material and doing, and that's more of an abuse or an harm which is being done to a child. And for that matter, recognizing that there has to be a seriousness given to it, so every aspect to it, right from somebody making it to somebody downloading it to somebody watching it, somebody keeping it. That can be for the purpose of watching it alone or sharing it for that matter. It can be different types of ways of sharing it, offline mode, online mode. But that entire thing has to be considered in toto as a crime. There can be a layer of it as to what consumes as what kind of punishment entails if you're creating it, and what type of punishment entails when it comes to you watching it or downloading and keeping it. But all these things considers to be a crime because we're talking about something which is very heinous. The ramifications when it comes to sexually abusive material which is being shared across and downloaded, we are seeing that despite so many laws in place which are there, despite each and every country in the world recognizing that as a crime, there has been an enough and more of a market. Such material is always being shared and it is available on social media platform. People have it. To put a hard stop to that, there is no differentiation when it comes to giving a leeway to somebody who has downloaded and is kept it in his phone, but not himself sharing it or creating it. No demarcation in that manner. Everything is punishable without any giving any kind of exemption to anybody in that line, which I would say is a welcome move. We would need that
And it's
so that
important, Khushbu.
a stringent, yes.
Yeah. And yeah, Khushbu Jain, it's also very important to, again, the semantics of it, which the Supreme Court has stressed upon, because when you look at, when you see the term child pornography, the term pornography, while it may have different reactions in society in terms of how their moral views are, essentially pornography involves the consent of all the actors who are featured in it. But in a child pornographic video, the child's consent is immaterial because the child, by very definition, is below the age of 18 and is not in a position to give consent. So you're automatically, by its very nature, looking at children being exploited and being put in positions where they don't really understand what is happening and what they're going through, which is why it's so important to categorize it what it is. It's not pornography involving children. It is essentially exploitation and abuse of children.
Absolutely. Is it the question to me again?
Yes, that is the
Yes.
question to you.
Yes. So if you see, absolutely, I agree with you because you talk about exploitation and degradation of a child for sexual gratification by an abuser. This is nothing but just that. So any kind of production of child sexual exploitative material is in a way inherently linked to the act of a sexual abuse. So if you'll have to see, it is very clear that this is an exploitation and this is an harm which is intended knowingly to a child. And creation of such kind of material is not a passive act, but a deliberate one where an abuser is intentionally engaging into an exploitation of the child, knowing very well that this will harm and what kind of harm it will cause on that child. So practically this crime will be nothing but heinous crime, and anybody who is violating this not only by creating it, but also reducing a child to an object for their own gratification is somebody where he is hurting or where he is hitting the dignity of the child, the well being of the child, or in a manner, if I have to put it in a nutshell, dehumanization, which is absolutely evident in such kind of production, distribution, watching
Absolutely.
of such kind of content. And for that matter, is where I think that definition is also being changed from pornography to CSEAM, that is child sexually uh, 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 I'm missing on the word.
Exploitative and
So
abusive material. It is a
abusive,
mouthful.
explicit
It is
abusive
a
material.
mouthful, Khushbu Jain ji. It will take us some time to get used to it. Yes, but it's very important that we start calling it that. Even though if it's a mouthful, it's not really the most convenient abbreviation or acronym, but it's very important we start calling it that in a lexicon. I'm sure you'll agree as well. Let me also bring in another senior advocate, N.S. Napinai, who is joining us on the panel. Ma'am, thank you for speaking to Mira now. The sheer number of cases while me and our team were researching in terms of the increase in statistics which talk about violence against children, about cases of violence against children, about arrests in terms of cases of violence against children, in terms of the sheer number of increase of CSEM material on the internet here, in which we have seen more than 100%, 200% increase in cases in just the last few years. This indicates a very concerning trend, which is perhaps one of the important reasons why the Supreme Court came out with such a strong judgment, which has been hailed by the CJ as such a landmark judgment here, because there is genuine data on record which indicates that this is a threat that needs to be addressed with a holistic approach involving the legislature, the judiciary, and the executive.
Indeed. But let me just give you a little bit of perspective here. The first and foremost is CSAM is not a new term. The only difference is when the world opted for CSAM, which was child sexual abuse material, India opted for the term child pornography in its law. And the second aspect of it is the introduction of the provision under the Information Technology Act of child pornography under 67B, and also revamping of the POCSO Act to include various kinds of child sexual abuse material, as it was called globally then, was not a standalone act by India. It is actually something that came out of international laws, and that is also captured by the Supreme Court. The primary one being the Budapest Convention and the Protection of Child, Universal Protection of Child Rights Convention. Now, the one thing that is missing in the decision is you now have a new ad hoc committee draft text which has been approved and has been submitted for finalization and ratification, and that clearly sets out two provisions which are meant to protect against child abuse. Now, the addition of the one word exploitative is very critical, and it again captures the trend globally. Now, if I could just give you a little bit more perspective in terms of what has happened and the background to why this case came up, I called it in my article, which I wrote the day after the Madras High Court judgment. I called it a black letter day for the Madras High Court. I must say that today is a red letter day for child protection online, because we needed clarity and certainty to show the world that each aspect in terms of violating a child's rights, be it in terms of just viewing, downloading, watching, creating, etc., each aspect of it is an offense. The way in which the Supreme Court has set out in the judgment what amounts to an offense by giving examples, by telling you that, how you download it, how do you retain it, when exactly will it amount to an intention to share? Because it's not just talking about sharing, but even the intention to share being an offense, the manner of giving examples, illustrative examples, and then setting out what is the offense makes it very clear to the world what, or I would say for India, what is or is not an offense, including the importance of sex education, which is also, mentioned with respect to being age appropriate.
I am so glad. I am so glad you mentioned that, ma'am. I was actually waiting for that to be a mention as well, because as you mentioned on, it's a red letter day for the Supreme Court, not just in terms of understanding the semantics and the terminology and following international norms, but also putting a push for sex education. And before I go across to my other guests as well, I would quickly like to direct our viewers' attention to what exactly the Supreme Court said in its push for sex education here. The first thing the Supreme Court said was that it's important to implement comprehensive sex education programs in schools. It's important to educate children about the legal and ethical ramifications here. Also, the Supreme Court said that programs should address common misconceptions about what is consent, what is not. There has to be clear understanding of the term consent amongst young people needed, and it's essential to educate young people about the impact of exploitation at this point, and so that they understand what is exploitation and what is consent, and more importantly, when are they in a legal age to be able to give consent. Let me bring in Soumya Jogi and Meenu Pada at this point. Meenu Pada, let me start with you first. This is very, very critical because a lot of cases of POXO and child sex abuse are also having minors as not just the victims but also the perpetrators, because they are at an age of experimentation. They experiment sexually, and sometimes when it gets to know, when it comes in the knowledge of the families or the guardians or the school or the police, it becomes a POXO case, and you have the minor accused also brought into the case, made an accused in a POXO case. Having effective sex education in schools and public spaces also ensures that even underage children understand sexual boundaries, understand the concept of consent, understand the concept of exploitation. This is a very important debate that has been triggered by the Supreme Court today.
Absolutely. Um, I think, first of all, I would like to say that I firmly stand in support of the Honorable Supreme Court ruling, which unequivocally recognizes that downloading and viewing child sexual abuse material is not just a legal issue, but a moral outrage as well, and a serious offense against the most vulnerable member of the society, that is, children. And the recommendation to redefine this term, the child pornography, as sexually abusive and exploitative material, is a transformative step, actually. This terminology shift reflects the gravity of the crime and recognizes the profound harm inflicted on the children. And it moves away from minimization often associated with the term pornography and underscore the reality that these materials are manifestation of severe abuses against children. And this ruling make it clear that the act of consuming this material perpetuates a cycle of exploitation, and each instance of downloading or viewing such content contribute to the demand that fuels these heinous crimes. Accountability is crucial, and we must recognize that consumer of this material are complicit in the abuse of children. And the Madras High Court judgment, Madras High Court order that viewing child sexual material is does not constitute an offense is not only troubling but also dangerous, I would say, because the Supreme Court intervention is critical in reinstating the seriousness of this issue. So, correcting the significant legal misunderstanding, and that could have led to a further victimization of children. About the sex education, sir, to effectively curb these issues, we must obviously introduce, we must have to introduce the comprehensive sex education in schools and all over India. And education empower children with the knowledge about their bodies, consent, and the personal boundaries. It equips them to recognize inappropriate behavior and understand their rights. By fostering open discussion around sexuality and exploitation, we can build a resilience among children and reduce their vulnerability to abuse. I would like to mention here the Kerala High Court judgment in one of the bail application, where the Kerala High Court, I think in 2021, I'm not able to recall the exact citation title of the case. Kerala High Court directed the CBSE and the State Board of Kerala to introduce a sex education in their schools, in every school, whether it is a government school or private school, according to the age-appropriate curriculum. And right now, I have also filed a public interest litigation in Jammu and Kashmir High Court with regard to the same. And in this time, when Supreme Court a special mark with regard to this sex education. So I think this is a positive step, and we are looking forward to this to be implemented in all over India.
It's evident, Meenu Pada, that the courts, not just in the Supreme Court, but in the high courts as well, through conversations and through activism by lawyers such as you, there's enough of a discourse going on within the courtrooms about the need for child sex education. How do we ensure it's a reality now that the Supreme Court has actually set the ball rolling? Let me bring in Soumya Jogi on this point. Soumya, the discussions that go on about the need for sex education is something, it's not an old debate. We have all known it for years now. But as someone who has a ringside view to understanding how it actually plays out, what are the key areas where even today, perhaps sex education, as at least sex education that is taught in classrooms, still falls short of actually being something which liberates and truly educates children rather than just become yet another subject of the curriculum?
I think the very fact that our reaction when we hear the word sex education, right? You and I and all our viewers here will have a reaction, right? We'll be a bit taken aback.
Yeah,
A lot
yeah.
of parents will be thinking about who gives the consent, like what is age appropriate, right? So when you talk about the word sex education, that itself causes such a huge perceptual issue. Sex education is important, but perhaps I would
Hmm.
like to offer that we propagate it in such a way where it is more child empowerment, right? Even if right now the word sex education is not very easily accepted, the fact that we are having programs that empower the children and help them understand what is good and what is bad, something as simple as good touch, bad touch, tricky people, understanding consent, creating space where they can express to their teachers or their parents, right? And this workshop is not just necessary for the students. Something like this is very crucial for the teachers and parents as well. Imagine a child, all right, coming to you as a parent and telling them that they undergo something horrible like this, right? No parent will know how to react properly. Even worse is the teacher's condition
Exactly.
of how are they supposed to act? How are they supposed to behave, right? Sometimes all this becomes news stories, things that are there out there. But when we often don't think of these disasters as something that we ourselves have to face. So a lot of these protocols need to be created so that in a situation such as where a child is expressing this to their teacher, that educator knows how to react, that parent knows how to react, and the child himself or herself is empowered through these programs. Call it sex education or call it something else, but give them that education, give them that
Hmm.
resource so that they can do what needs to be done and protect themselves.
Soumya, I couldn't agree more with when you said in your opening remarks that the very nature of very mention of the word sex automatically causes a sense of panic. My parents are watching the show. I was seriously considering whether to ask them not to watch this show. And I'm a 35-year-old man. If I'm so awkward discussing this on national television, imagine what so many of our parents do. But I just wanted to bring you in also on this issue of semantics, which I began this debate with Khushbu Jain. The deliberate delineation that the Supreme Court has done, Soumya Jogi, between pornography and CSAM. And that is necessary because there's also a parallel debate going on about as to whether porn should really be seen as a dirty word, given the fact that it is something which, let's face it, is very intrinsic to children's sexual awakening and education, especially, Soumya Jogi, when it comes to their teenage years, when they're trying to discover the sexuality. It's very important that a delineation be done that pornography by itself might not be a negative word or a dirty word, but pornography involving children is an absolute no-no, and there should be no two ways about it.
No, I don't agree with that completely because pornography itself is
Okay.
not something that a teenager will be able to very readily understand, right? Because there's something called addiction to pornography. Even if it's not child pornography, it does affect the teenage brain. So no child needs to understand or learn sexual education through porn, though that is where they do in reality get the maximum of their information. I don't disagree with that, but it's not a very healthy way. So I do not think that we need to make the term porn less abrasive, less harmful. Let it be. But the fact is that the awareness about child pornography as a topic or any sexual exploitation of a child needs to be brought into limelight, right? From a young age, boys and girls both need to understand what is right, what is not right. They need to understand consent. They need to understand their rights. In that way, they'll be able to protect themselves and spot if something wrong is going on with someone else, right? So as far as teenage years go, I do not think we need to touch pornography as such. And as far as elders, be it above 18, they are old enough to make up their own minds about what the word porn means. right? But the awareness of what child pornography is
Okay.
and the consequences of indulging in child pornography is something that needs to be brought into awareness. Sometimes what happens is because it's happening in the virtual world, you're having that anonymity ka cover, right? You don't feel as if you're actually doing something wrong. But that's not the case. The awareness needs to be brought
Okay.
into the picture that even if you're in the privacy of your own home, what you're doing is still wrong.
Okay. Interesting point being made. Meenu Pada, would you like to comment on that and weigh in as to whether you feel that pornography, or at least the issue of pornography, is something that needs to not necessarily be included when we have the conversation of sex education with children or with teenagers, because that is something which teenagers need not really be exposed to. Whether does that really happen in reality?
Sir, obviously, children are among the most vulnerable section of society, and this term pornography is itself is, I guess, not good. So I would say the term that has been introduced by the Honorable Supreme Court to use this word instead of
Okay.
pornography is the uh, child CSAM. It's like child sexual abusive and exploitative
Yeah.
material. So I think obviously this word is not good for children to understand. And about good touch, bad touch, I would say that is also very important to be introduced in school. And I think this will also play an important role to curb these kind of cases in our country.
Okay. Fair enough. Let's pivot a bit more to some another important aspect that came in from the Supreme Court verdict today, and let me bring in Khushbu Jain on that as well. Khushbu ji, the Supreme Court Justice Pardiwala's verdict was very clear that it expects now the legislator to take the step forward and come up with an amendment, if necessary, to the POCSO Act, which clearly specifies what the boundaries which are, and in order to ensure that what we saw as a verdict which came out from the Supreme Court gets crystallized as a law. What are the challenges that then come out? Because from what I understand, the legislature generally does not like being dictated to by the Supreme Court. It prefers to have its own wisdom based on the fact that it represents the people's will. I'll get you in as that, and after that I'll also get Napinaiji's views on this important question.
The only aspect that has to be looked upon here is, yes, we see that legislature don't want to enter into it or do not want to look into it, but there is more to it when it comes to, we are living in the age of technology and we have to see both the sides of it. I understand that we are not looking into the aspect when it comes to you're downloading it, and if you've downloaded it, it should be equally punishable. But see, when you create a legislation, one has to also understand that we are living in the age of technology. When it comes to laws can be made, but when it comes to enforcement, that also have to be looked into when a law is being enacted. So there, I think there are some contours that has to be looked upon when legislating these kind of things, and that can be, see, you have WhatsApp with you. You are added in lot of WhatsApp groups. Now, the moment you have auto download, there can be some material that can be downloaded and kept in your phone, and you have not looked upon it. So that's the another area which is also discussed by the court, that we are not considering that and giving that as a leeway. But these have to be looked upon, because tomorrow, if such kind of content is there on your phone, and if we are not going with the intent part of it, this will create a lot of issues, and there can be an aspect where people who are not genuinely indulging into it will be the one which will be caught. So that's where I think a line has to be drawn, and legislation has to come to look and see that how things can be implemented and what are the precautions that has to be kept when it comes to such kind of uh, uh, changes that has to be made in the law. See, one more point.
All
One
right.
more point I'll add.
NS
Apart
Napinai,
from
I'll let you have the last word. Yeah, please go on, Khushbu. Please go on. Yeah.
one more line I want to add. Again, as I said, we are living in the age of technology, and we are living in the age of internet. See, you have to see one more aspect to it. One is act which is done, which is heinous. A child has gone through the entire aspect of the abuse that has been gone. He's living with that abuse. Now, the second that comes is that abuse is recorded. Second layer of torture. The third that comes is it is being uploaded and shared. The fourth, that it is there and it is continuously going. We say that nothing gets deleted from the internet. Some copies keep on going, and it can be offline in a lot of places, and you have to live with it forever. So practically that abuse deepens into a psychological impact that deepens every now and then, that you have to live with it. So that entire thing also has to be looked upon and kept in mind when you talk about aspect of child abuse and child abuse exploitative material which has been circulating on internet.
All right. All right. NS Napin, I let you have the last word as the senior most on the panel. Where do we take things from here? It's evident right now from your comments as well that the Supreme Court today has come up with perhaps the most significant verdicts we have seen in a very long time. But it has also made it very clear that this is a conversation that the ball does not stop here. It has to be kept rolling. And the next turn is that of the legislator by coming up with a law and by ensuring there are the relevant changes are reflected in the POCSO Act. What, according to you, is the way forward, which if our legislators are listening into this broadcast, they need to keep in mind in order to ensure that the benefits or at least the historicity of the Supreme Court verdict today is upheld in subsequent actions?
For me to answer that, we'll also have to step back a bit. If you look at, you talked about the increase in CSAM material online, and you mentioned about 200%. It's unfortunately a lot more than that. If you look at one New York Times article, it traces from 1998 onwards, where we had a few thousand CSAM online. You're talking about millions now. And unfortunately, the statistics that comes out during the COVID lockdown shows us that a substantial part of those millions were India-based, either India-based browsing or India-based content. So we really need to take action in an effective way. Why I said we have to step back is we are talking about a New York Times article which traces from 98. The Budapest Convention that I told you about is of 2001, which introduced CSAM as a specific requirement for signatory countries. Though India did not sign that convention, we still included 67B. What is it that we are seeing from 2001 to now? And for India, it was the 2008 amendments that brought it in. But from 2008 to now, have we seen a reduction? So is it really inclusion of more provisions that is going to help us? Or is it better implementation of the existing provisions that is going to help us? So the way I read the Supreme Court's, spotlighting the essentiality is for clearer and simpler provisions which are easy to implement. We need to streamline the implementation process to show that laws which are being enacted are effective and are going to then act as a deterrent. If we are not able to show that they can be enforced, if we cannot show that if you watch CSAM, then you can be traced, prosecuted, and punished, then just adding a few more sections is not going to help anybody.
So then what is the roadmap? Like, I know you've already touched upon this in your answer, but it's very important getting in your perspectives here. How do we look at better policing, better implementation? Because our police system, in fact, even a court system are already saturated. And let's be honest, I wonder how much of an average policeman or a policewoman, no offense to their abilities, they will actually understand the sensitive differences between CSAM and pornography and other aspects here. So how do we actually go about with this process?
One of the critical things that the Supreme Court has done by changing the phraseology is because there has been time and again reiteration of this position that watching pornography is not an offense. Unfortunately, the Madras High Court made a grave error by equating the watching of general pornography, the adult pornography, with child sexual abuse material. And that was one of the criticalities which resulted in the overturning of the judgment. So today, when you're talking about renaming it, the first step that happens is bottoms up. Everyone in the system understands the difference, including with respect to just watching of pornography. Secondly, this is not the first Supreme Court judgment which made a big difference with respect to CSAM. There was a case earlier, and that was an interim order as of October 27, 2017, in the case of Prajwala, which dealt with the uploading of CSAM and rape and gang rape videos online. That was the first step which has helped India implement very strongly the existing provisions to combat CSAM. What it did was it created firstly a sign up with this US organization called NCMEC, and through the collaborative effort with social media platforms and other platforms like chat apps, etc., we are able to now get information to trace offenders and to prosecute them. Now, creating better awareness about the kind of success stories that are coming up. For instance, Maharashtra launched just before the COVID lockdown an initiative called Operation Blackface, which was meant to trace out and prosecute child sexual abuse offenders. So better awareness amongst public that these kind of initiatives are being commenced in India, the success rate that they are seeing, the kind of convictions that are coming out of it, these are the processes which are going to help. Why I mentioned some of the background information is to show that it is not so bleak. You don't have to think that just because you're online, you're going to have this absolute invisibility cloak that nobody can breach. You can still be traced, and it's very critical for us to keep reiterating this to make sure that offenders understand that they are committing a crime and that they can be prosecuted and put behind bars.
All right. So it's very evident at this point from what my guests have been telling us that this is a landmark judgment, but as we have been discussing, in order to truly ensure that there is a new lexicon which is affected in the public consciousness, all aspects of implementation of society, this conversation needs to be taken forward and needs to be done so on multiple levels. Khushbu Jain, Soumya Jogi, NS Napinai, and also Meenu Pada, thank you so much for joining me on this, frankly, very illuminating discussion. I've enjoyed having this conversation with all of you.